Yeah, they better not put their hand on me.
Okay, Mr. Brooks, you need to look at me for a minute, okay?
Why? To listen to all this political stuff y'all got going on?
Mr. Brooks, I'm more concerned about...
Don't touch me, dog.
Stay seated.
All right, we're going to take a break and we're going to come back after lunch. I'm not going to do this with him right now. He needs to be here. He's not cooperating. I'm going to give you the warning, Mr. I will give you the warning that if you continue to interrupt when we go back on the record, you will forfeit your right to be in the courtroom today. I can't have these interruptions. I want you here. It's been a long day and a half.
Keep your hands off me.
We'll come back at 12:30.
Just told you to get up off me.
Don't seem to understand.
I believe that fully.
I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what nobody you don't gotta explain nothing to me.
Do you want
That's what you don't understand. You think that this is a whole game to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things on the
unfair.
ship
It's
that's going
unfair
on.
and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a joke.
What type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So
And I understand.
I think, Your Honor, with all due respect, I think you should show some
we're going to take a
respect.
5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in recess.
No, you're not rushing me to judgment. I don't care what you're talking about.
So what other details do you not recall?
Objection. Your Honor, how does someone recall the details that they don't recall?
Yeah, that's what I wonder.
Sustained
How
is
do you
to the
recall
form
some
of the
details,
question.
not others? Seems very funny. Seems almost as if you're recalling what you want to recall and purposely not recalling.
Objection.
Don't-
Badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue. What do you mean?
Next question.
What do you mean?
Don't intimidate the witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding
That's
her
Does she
answers
feel intimidated?
is badgering the witness.
Are you kidding me?
Under 90611,
You really
please
can't- you
ask
really
your
can't
next
be serious.
question.
You can't be serious right now. Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form can
But you
be.
said
Mr. Brooks,
intimidate.
I've made my ruling under 90611.
specifically said
Please
intimidate.
ask a question or
I'm trying
I
to
will
merely-
stop the
How
questioning.
did I intimidate?
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question or the questioning of this
How
witness
are you
will
even
end.
a judge? How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the 62Q trust, right? That you want to be the beneficiary of?
I am going to give the jury their closing instruction. We are done with testimony for today.
They ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If
So
I want her to be here, she gonna be here.
I agree with
So
the
just
state
just know
that
that.
she could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you
We
to
said-
have her
we
here
said
at
all
9
that- We said
a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of
I need to make a record too.
You don't
When
need
am
to-
I going to get the chance to do that?
All right, I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make.
I'm finna
He
leave
hasn't
anyway,
sat
so
down
we'll do it
for
now. You
the
can
better
hold
part
me
of
to
2
all
hours.
you want. You can hold me in contempt all you want.
I'm not holding you in contempt.
All you gotta do is tell me if it's criminal or civil, so I can hit you with you.
I need to clear the courtroom because I do need to
I'm gonna give you what you know is coming.
I need him to go to the
If
other
it's civil,
courtroom because I do need to put some things on the
civil,
record. The record should
Where's the
reflect
contract between you and I?
that Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what
He
is
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no
to the next
It ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system. As I've let you do. You've even went so far as to mute
Mr.
me.
Brooks, the
Which you
jury
can't
is
even,
coming
there's no
out.
lawful law to say that you
I'm
can even
advising
mute me.
you to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say that you can utilize the mute button? It does not.
Mr. Brooks,
So
when
you're-
the door
you're-
opens, I expect you to be quiet.
You're,
and you will
you're,
forfeit
and I
your right
expect
to
for
be
you
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom. Please, take me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in contempt. Hold me in contempt. I have.
I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off because I can see the outline of his arms, and I can see the jacket on the back of this chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so we
Yes,
can
I think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there. He has quieted down. I haven't heard him in a while. If you could move the second one because it can interfere with the microphone as well. And the third. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my body?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey man, you don't gotta talk to me like that.
Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though, cause
As it relates to the jury instructions, sir, what are your?
I heard what the hell you said, man. You just been making all the decisions for me, even though you know I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm telling you I don't understand, and you still make a decision determining my life.
Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you said.
Then you should put the headphones
What about that
on.
don't you understand? What about that don't you understand? If you see headphones, you can see everything, you can see
Have you asked for headphones to be provided, sir?
I shouldn't have to ask for them. I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated. They were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you're doing and think God don't see what you're doing. You ought to be ashamed of yourself.
What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones?
Yeah,
choose
because
to
I'm
read?
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that I don't have to hear the disruptions.
Okay, well then why should I need to hear what
So
you
let
say?
me be clear, sir. And you
don't
are
gotta
not.
be clear nothing. I don't gotta listen to you.
This.
We gotta keep doing this little childish stuff, dude. I gotta sit up here and I'm supposed to abide by every single rule, but don't nobody
This
else
is the
gotta
judge's
do that.
fault.
The record should
Judicial misconduct.
reflect that Mr. Brooks is spouting off, making unsubstantiated allegations against this court, directly attacking the integrity of this court and these proceedings, while yet refusing to answer simple questions. Mr.
I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
Well, you can't ask that, but you can ask them if they've met with anyone ahead of their testimony here today, which you've done with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I saw them reach for
by
something.
you
Oh,
to
I don't.
delay these
I don't recall what they had on.
Mr. Brooks,
You can
there's no
recall seeing
purpose
somebody
for you
reach
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
Before we do that, there's an issue that we do need to take up potential as to witness.
You want to run the record back?
Mr. Brooks,
So I'm the only one. I got one.
Mr.
I got
Brooks.
one ear that work, and I heard that.
this
Come on,
is
man.
to benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit me,
witness
so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescott.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can
believe
you
he has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break. Please stop.
Which means someone is being sued. Civil is a suit.
Mr. Brooks, you're talking about an irrelevant matter.
I have the
I'm
paperwork
starting the
sent by
trial.
The paperwork right here that says it's a civil matter.
Mr. Brooks
So
has
what's
nothing
being
to
sued?
do with
My
this
session
case.
trust is being sued.
I have no idea what you're talking about. So,
I got the paperwork right here.
all right, I'm
How
going
do
to
you
excuse
not know
the
what I'm
jury
talking
right
about?
now, given this disruption. I'll rise for the jury.
This should be properly addressed before the jury even comes out. That's why I tried to properly address it before we even went on the record.
Mr. Brooks, stop. In Illinois versus Allen. I also referenced yesterday a persuasive case. It's not at my fingertips. I'll get that for the record. It's the Pennsylvania case that I found to be of persuasive value, where a similar procedure was done. Frankly, what we are providing here in Waukesha County through the use of the technology we have in the courtroom is far superior to what was done in that Pennsylvania case. want to do that. Oh, you don't? I changed, hold on. 76, the 76 count, just want to make, it says near Frame Park, so it is in there, but that was just one question I had. All right. So state have any requests as it relates to the jury instructions?
Your Honor, I'm just going through each one. I'm on page 50 of 107.
325, 141, and 170. Do you have any requests as it relates to the jury instructions, sir? I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off, because I can see the outline of his arms, and I can see the jacket on the back of his chair. He is unmuted, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so we can
Yes, I think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there. If you could move the second one, because it can interfere with the microphone as well. And the third. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my box?
Because I couldn't see you, sir.
Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter. So who makes the claim? Who? I'm not stupid.
Well, I disagree with. Provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you opened the door to the playing of that video.
We're not talking about
and the
opening
video was
those doors.
previously provided to you during discovery.
We're not talking about opening those doors. We're talking about being fair.
There's absolutely no prejudice to you.
Your Honor,
in
with all
terms
due
of
respect,
surprise.
with all due respect, if I had done that,
I am going to move on.
If I had done that, it would have been a big
I'm
thing.
advising you.
Are you asking me?
I'm advising you, sir.
Oh, okay.
I'm advising you to sit down and be quiet. And if you interrupt me again, you are on notice that you will forfeit your right to be present in this trial.
So you're holding me in contempt.
There will be no multiple opportunities where I give you to conform your conduct to the rules of decorum and courtesy.
Then just hold me in contempt then, Your Honor.
You are
hold
hereby
me in contempt, because I didn't even, I'm trying to seek to understand.
If you start talking about subject matter jurisdiction or any of these other issues.
It needs to be addressed,
or
Your Honor.
in any way
we're not talking about subject matter jurisdiction. We're talking about why my due process has been violated.
I will excuse the jury and you will be removed to the other courtroom.
We're talking about the 14th Amendment. Section
I am
1.
taking a 5-minute break. We are
Your
in
Honor,
recess.
I don't agree to a estoppel. I don't agree to a
estoppel.
estoppel. Your Honor, as a because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're going to get through these witnesses.
And I'm not stopping you from doing that.
Through your behavior, you're not going to delay these proceedings today.
I'm not trying to delay the proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that.
You don't know
Mr.
what
Brooks,
I'm trying to
reading
do.
the jury out. I'm not going to argue with you.
Then
So-
don't. Because I'm not arguing with you either. I'm stating facts.
You're raising your voice. It's very
Because
angry
I'm
tone,
tired of you
and
always
it's
making a
yelling
record.
at me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not going to work.
I'm making a record of what's accurately
You're
being
making
done
a
in my
record of
courtroom.
incorrect statements. That's what you're doing. You're not making a record of
Mr.
not
Brooks,
being
I'm
able.
advising you to be quiet because the jury's coming back out.
You're advising me to be quiet? Is you telling me to be quiet?
I'm advising you to be respectful when the
Are
jury
you
comes
telling
out.
me to be quiet or are you asking me?
I'm asking you and advising
Okay.
you.
Thank you for correcting that because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
We're all
if you
we're
lower your
all
tone
adults
of
in here.
voice
I've
and
never
not yell
told
at
you
me,
to do
sir.
anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work.
It would be fair to say that if there's details you don't recall, how can you recall the path of travel of the SUV that you claim you saw?
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask you. You just acknowledged that there may be some details that you don't quite recall. So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
Judging by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
So you recall all the details of what you observed that evening, November 21st, 2021?
No.
So what other details do you not recall?
Objection. You're under, how does someone recall the details that they don't recall?
Yeah, that's what I wonder.
Sustained
How
is
can
to
you
the
recall
form
some
of the
details and not
question.
others? Seems very funny.
939.50 sub 3 sub F and 939.63 sub 1 sub B of the Wisconsin statutes. The 39th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lola Hospital under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 40th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street, in the city of Waukesha, you waived your right to counsel.
I didn't waive my right to no counsel. I
You
gave you the
waived your
contract.
right.
I did not. And you won't sit here and say that for the record because that is not
No,
what happened.
you are
No.
incorrect.
So we don't have the, do we have the
In your-
paperwork? Because I believe that I gave you the paperwork back that you,
Mr. Brooks, you
I
very
gave it to you, altered,
clearly
and did not waive it.
have been presenting a nuanced argument regarding
That is
the
not
right
true,
to
Your Honor.
counsel
That is not
versus
true.
the right to assistance of counsel.
That is not true.
That's a pretty sophisticated argument. That's why I believe you fully understand what's
I
going
don't.
on in this courtroom.
I don't fully
I
understand.
disagree with your
I
characterization
disagree with your
of the
characteristic.
right to counsel.
You know that you accepted
You
the way that I
waived
gave it to
the
you.
entirety.
So you shouldn't have did that if you had questions of me not understanding.
I don't have any questions whatsoever.
You definitely
sir.
do, because I'm telling you right now I don't understand, and you still won't even acknowledge the fact that I'm saying in open court on the record that I don't understand something. I haven't waived anything. You made decisions today
that I didn't consent to, that I explained I did not answer because I didn't understand, which is my right to say that.
Right, Mr. Brooks, you
It's
are
also my Fifth
interfering
Amendment
with the
right to
proper
be
and
silent.
orderly administration of these proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper legal recourse at this time. I have asked, if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. Of course, this comes on the record before this court over the first 15 days of trial where Mr. in court.
I just said no. How many
Okay.
times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And
yes,
everybody
we can hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic.
Because
where you try to
it's not a
go
tactic,
off of
it's
what
facts.
we're talking
It's
about
facts.
to some other
It's
reason.
facts.
to
Because
some
I
other
find
thing.
it hard to believe that
I'm going to
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the state
man,
make
stop.
a record of why they
Stop.
believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from him?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let the
that.
state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct...
It's not
Stop
accurate.
talking.
What you mean, stop talking?
I need to make a ruling. Okay,
Well,
I'm
let's-
purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's
right
talk to
now.
each other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answered
cell?
my question. We'll move on.
I'm
not
trying
taking
to
that
understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're
I
in
know?
recess, 15 minutes
How do
from
I
now.
know
Take
what
care,
I'm supposed to answer if I don't understand? And I don't agree to a stop.
No, I don't want to do that. Oh, you don't? I changed, hold on. 76. The 76 count. Just want to make. It says near Frame Park, so it is in there. But that was just one question I had. All right. So, state have any requests as it relates to the jury instructions?
Your Honor, I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far, though.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
I put 325, 141, and 172 at the end because it was short.
Yeah, that's okay. To come back into this courtroom as you call your next witness.
You're not finna hold me in contempt no more.
Not finna do that.
Mr. Brooks is not answering my question directly, so based upon that, I'll advise him that if I will ask one more time and he fails to answer it with a yes or no, I will take that as a no, that he wants to stay in that courtroom.
You can't
So,
answer
Mr.
for
Brooks?
You can't do that. You can't do that.
Mr. Brooks, I'm advising you that I will, he's interrupting me once again from
Okay,
the other
you talking.
courtroom.
You the one talking right now, so don't do that.
I'm going to
Don't.
mute him because he's not being respectful and he's just spouting off. So he did not answer my question directly. He has not reclaimed his right to come back into the courtroom because number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial. Do you want to be present at that?
For the record, I'm not a person. I'm a human being.
A functional equivalent to being present in this courtroom. He's able to see, he's able to hear, we have video, we have audio. He has consistently been provided with all of the materials. If the materials are here in this courtroom when we start out, but he's removed, they have been taken to him. He has been provided with paper and a pen so that he can communicate with the court. I can tell from his demeanor right now, he's doing a clapping type motion. He's doing it once again. It's a clear indication that he can hear this court. I've also confirmed with the bailiff.
From 2006.
Right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break. 50 sub 3 sub H of the Wisconsin statutes. Bail jumping, as defined in section 946.49 sub 1 of the Criminal Code of Wisconsin, is committed by one who has been released from custody on bond and intentionally fails to comply with the terms of the bond. Okay?
See, I didn't interrupt you. See,
I'm sorry?
I said, see, I didn't interrupt you.
Thank you, I appreciate that. I would like the parties back in about a half an hour. Thank you,
Because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the
finish.
end of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me
disrespectful,
she was.
interrupting.
We can ask
He's-
that question
he is
too. Then
over the
Did you
top
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
no,
finish.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. I'm pro per. I have the right to conduct my defense pro per, free from professional restrictions. Everything I'm doing is off the top of my head. I have full judicial power of the state, or is this military power? Common law court or an admiralty court? The plaintiff in this matter, the state of Wisconsin, it's treason. Be allowed to testify, not to uphold your oath of office. It's also aware that I only had 3 days. My Sixth Amendment right has been basically trampled over to prepare for a trial that the prosecution has been prepared for a whole year. I think it's safe to say that my speedy trial right has comes attack a degree definitely been violated. I have the right to ask for that, and these are all valid things legally. Rather hanging out from time to time, having a cup of coffee. I move for this case to be dismissed for failure to appear. I'm just asking for your honor to state a claim.
Mr. Brooks, I've given you about 50 minutes to make your various arguments. You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have any response.
Many of the topics that Mr. Brooks has now recited to the court are incomprehensible jargon and cut and paste legal mumbo jumbo.
Guilty of first-degree intentional homicide as charged in count 1 of the information. Dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that.
Thank you. First and foremost, our thoughts and concerns remain with the victims involved in this tragedy and their families. Although the defendant devastated our community, the people of the city of Waukesha, Waukesha County, and beyond demonstrated tremendous resiliency. We are so grateful for the first responders, citizens, and medical professionals who sprang into action and immediately rendered aid and saved so many lives that day. We appreciate the jury for their work and dedication to justice. We commend the police officers and citizen witnesses who testified or were prepared to testify and asked to relive the events of that horrific day. We are satisfied that this defendant has been held accountable for his actions. He now faces imprisonment of 6 consecutive life sentences plus 859 years of confinement. There is much healing ahead for the victims and for our community, but we hope today's result is a step further along that path. Remain strong, Waukesha. Thank you.